Welcome to This Explainer. We've all seen how incredibly complicated things can get when a massive public health crisis collides head-on with government policy. Today, we're setting the stage for what is honestly one of the most impactful legal dramas of the modern era. We're looking at a landmark case that sits right at the intersection of public health, constitutional law, and the fundamental limits of state power. It's the story of the Minister of Health versus the Treatment Action Campaign, which was heard by the Constitutional Court of South Africa back in 2002. And this case isn't just about debating a medical protocol, it's a foundational story about what a government actually owes its people when a crisis hits.
Okay, let's dive into this. At the turn of the millennium, South Africa was staring down an unprecedented HIV/AIDS pandemic. The Department of Health themselves fully recognized the sheer scale of the disaster. In the year 2000, they literally called it an incomprehensible calamity. It was an absolute top priority for the government, threatening not just millions of individual lives with unimaginable grief and uncertainty, but it was threatening the very economic and social fabric of a newly democratic nation. To really wrap your head around the gravity of this situation, we have to look at this number, 70,000. According to government estimates at the time, ever since 1998, 70,000 children were being infected with HIV every single year. And this was happening primarily in one specific way, through mother-to-child transmission at or right around the time of birth. Tens of thousands of the absolute most vulnerable members of society were being born with the deadly virus. Which brings us to the core legal and moral conflict of this explainer. When a country faces a health crisis of this magnitude, how far must the government go to provide a cure, or in this case, a preventative treatment? What are the actual boundaries of a state's responsibility, especially when you factor in tight resources and strained infrastructures, but lives are imminently on the line?
Section 1. A public health calamity.
The medical intervention at the absolute center of this dispute was an antiretroviral drug called nevirapine, and the protocol for it was incredibly straightforward. First, the mother takes a single tablet at the onset of labor. Then, the newborn baby receives a few drops of the medication within 72 hours after birth. That's it. It was fast-acting, and by 2001, it was officially recommended by the World Health Organization specifically for preventing transmission at birth. But here is a truly wild detail. The manufacturer had actually offered this drug to the South African government completely for free for 5 whole years.
Section 2. The nevirapine restriction.
Now, you might be thinking, a simple free drug that saves babies' lives? That's an easy decision, right? Well, despite the drug being free, the government hesitated to roll it out universally across the public health sector. And this hesitation quickly built into a massive clash of perspectives. The government's policy was to restrict the rollout of nevirapine to just 2 pilot research sites per province. Basically, they wanted to test a comprehensive program safely at very limited sites before expanding. Meanwhile, the Treatment Action Campaign, or TAC, which was an association of civil society members, they demanded that this free drug be made available at all public health facilities, everywhere it was medically indicated. The TAC argued that by restricting the drug to just a few sites, the government was arbitrarily denying life-saving care to thousands of mothers and babies who just happened to live outside those specific catchment areas.
Section 3. The constitutional battleground.
Because neither side was willing to back down, this dispute moved out of the clinics and straight into the courtroom. The focal point? A fascinating legal concept called progressive realization. See, the South African Constitution is pretty unique because it actually guarantees socio-economic rights, things like housing, food, and healthcare. But it also acknowledges reality. A country with a history of severe inequality can't magically provide everything overnight. Progressive realization means the state has an obligation to take reasonable measures, but only within its available resources, to gradually achieve these rights. So a citizen's right to demand services is constantly being balanced against a state's actual bank account and capacity. The TAC heavily built their case on Sections 27 and 28 of the Constitution. Now, Section 27 guarantees access to healthcare services, but it's subject to that progressive realization we just talked about. But Section 28? That's where the legal argument gained some incredible weight. Section 28 says every child has the right to basic healthcare services. Period. No qualifiers. The TAC argue that while adults might have to wait around for progressive realization, children have an immediate, right-now claim to basic health care, especially when their parents are too impoverished to provide it privately.
Section 4. The government's defense. Now, we absolutely must look at the state's perspective impartially here because the government wasn't acting out of malice. They were dealing with the harsh realities of managing a deeply strained national health system, and their defense was rooted in some very serious public health concerns.
So the crucial point is that they built their defense on 4 main pillars. First up, efficacy. They were worried that if mothers took the drug but then continued to breastfeed without access to clean water and formula milk, the baby would just catch HIV through the breast milk anyway, totally negating the drug's benefit. Second, resistance. Administering just a single dose might cause the virus to mutate, which would make future treatments totally ineffective. Third, safety. Nevirapine is a potent drug, and they honestly feared unknown long-term hazards. And fourth, capacity. They argued that the public health system simply did not have the trained counselors and infrastructure needed to roll this out safely on a nationwide scale.
And this brilliantly illustrates exactly what the government was concerned about regarding capacity. This is data from Professor Schneider, which was heavily cited during the case. Just look at the glaring disparities here. While Gauteng province had 100% of its fixed clinics offering testing, the Eastern Cape only had 44%. The government used this data to show that the system's capacity for delivering basic testing and counseling was wildly inconsistent. Their argument was, how could they possibly mandate a nationwide rollout of a sensitive drug when the foundational infrastructure of testing and counseling wasn't even uniformly there? To summarize the government's stance, the true financial and logistical cost wasn't the nevirapine tablet itself. Remember, the drug was completely free. The real cost was the comprehensive package. The state argued they were trying to implement a sustainable, holistic public health intervention. They genuinely believed that just handing out a pill indiscriminately without the required counseling, testing, and formula feeding support was irresponsible public health policy. They wanted to use those pilot sites to learn how to do it the right way before rolling it out everywhere.
Section 5, the landmark verdict. So both sides presented incredibly compelling arguments, right? You have the TAC fighting for the immediate lives of newborns, and you have the government fighting for sustainable, safe, and system-wide public health management. But before handing down a ruling on the medicine itself, the court had to address a massive elephant in the room, the separation of powers. The government argued strongly that a court of law absolutely cannot dictate government policy or rewrite state budgets. That is the job of the elected executive and legislature. If the court ordered the rollout of this drug, wouldn't they be drastically overstepping their bounds? Well, the court ultimately delivered a resounding verdict. They ruled that the rigid restriction limiting nevirapine to just 2 sites per province was, in fact, unconstitutional. The government was officially ordered to remove those restrictions and permit the use of the drug at all public hospitals and clinics, wherever it was medically indicated, provided that testing and counseling facilities already existed there. The court firmly decided that yes, while they don't make budgets or draft policies, they have a strict constitutional duty to step in and mandate changes if fundamental human rights are being actively breached by the state's policies. Now, a fascinating, almost astonishing detail emerged during the proceedings that actually completely weakened the government's defense about a lack of resources. By the time the appeal was actually being heard, the government had already made substantial additional funds available. They had increased the national HIV/AIDS budget to 1.8 billion rand by the 2004 to 2005 financial year. The court definitely took note of this, pointing out that this massive financial increase effectively eliminated the argument that financial constraints were preventing the state from utilizing a free drug at clinics that already had counselors in place. The Constitutional Court recognized that waiting around for years to formulate the perfect, comprehensive program while a free, life-saving drug just sat on the shelf was fundamentally unreasonable. In their judgment, they explicitly stated that courts have a particular responsibility to protect constitutional rights and are obliged to forge new tools and shape innovative remedies to achieve this goal. Basically, they concluded that when the absolute most vulnerable lives are in peril, in this case, newborn infants, a policy that outright excludes them from an available safe intervention is simply not reasonable under the Constitution.
The TAC case fundamentally changed the entire landscape of healthcare rights. But, it leaves us with a profound ongoing question to ponder. As we look at massive global health challenges today, how do we actually balance a state's very real, very limited resources and logistical constraints against a citizen's fundamental constitutional right to life? It's a massive tension between the harsh realities of administration and the highest ideals of human rights, a tension that this landmark case navigated so brilliantly. Thank you so much for joining me for this explainer, and I really hope this gives you a much deeper understanding of this incredible moment in legal history.